Next, we'll hear from New Jersey, and finally, we'll hear from Illinois.
One of the lights in my room is not working, so I was wondering how many gun owners it takes to screw in a light bulb. Turns out the answer is 4. 1 to screw in the light bulb, and 3 to argue with each other as to whether the light should have been a Surefire or a Streamlight. Go figure. My name is Dan Schmutter. I'm an attorney in New Jersey and New York, and I've represented a number of Second Amendment organizations, including Second Amendment Foundation, Firearms Policy Coalition, CalGuns, the National Rifle Association, the Association of New Jersey Rifle and Pistol Clubs, Jews for the Preservation of Firearms Ownership, and an organization called Knife Rights that I think many of you are familiar with. Now, as I said, I handle cases in New York and New Jersey. I'd like to start with New York. I want to give an update on the New York City Gravity Knife lawsuit that has been sponsored by Knife Rights. I know a lot of you who've come to this conference year after year have heard me talk about that case. It's been going on for many, many years. This was our lawsuit against New York City to stop them from arresting ordinary folks carrying ordinary pocket knives, alleging that these knives were gravity knives. So arrests to the tune of tens of thousands of people. And you may have heard that we achieved a wonderful legislative victory when New York Governor Andrew Cuomo finally repealed the horrific law that resulted in all of these arrests and folks being jailed. But you may not have heard how it came about. Now, the key to this story is coalition building and what we might call big tent activism. Now, the effort involved 8 years of litigation and years of legislative efforts. Spearheading this all were, of course, Knife Rights Chairman Doug Ritter and Director of Legislative Affairs for Knife Rights, Todd Rathner. But what we managed to do was loop in a whole host of disparate participants in the legislative and the litigation effort to achieve what Todd has described as, quote, probably the only pro-Second Amendment law ever to be passed in New York. We had Democrats and Republicans, we had the New York Legal Aid Society, NAACP, ACLU, the Cato Institute, the NRA, unions, the New York Times, and all sorts of other people, all involved in that effort, either in the legislative side, the litigation side, and sometimes both. And, to show how such, this kind of cooperation can work, for 3 years, the New York legislature overwhelmingly passed a repeal of the gravity knife law, and twice the governor vetoed it. But you need to persist. And this year, the bill was passed again overwhelmingly by the legislature. In fact, I believe it was unanimous. And it hit the governor's desk just as the United States Supreme Court was considering our petition for writ of certiorari in the long-running litigation, Copeland versus Vance. And there was also another conveniently timed lawsuit called Krakow v. Vance. And I'm pleased to say that the bill's sponsor credited our 8 years of relentless litigation as being one of the material factors in getting the governor to finally sign that bill repealing the gravity knife prohibition. So we're very pleased with that, and it really does show that when you have a lot of different people cooperating, and when you think about this struggle and this effort as the type of thing that can involve all sorts of different people from different organizations, different groups, and different walks of life, you can really achieve extraordinary things, especially in a place like New York. I want to talk about another case. A number of people have already talked about the case before the United States Supreme Court, New York State Rifle and Pistol Association versus New York City. Dave Kopel spoke at length about it. I know Dave Jensen spoke about it as well. And you've heard that several of us have cert petitions that are now sitting at the court awaiting to see what the court's going to do with the New York City case. Don has the Pena case, Dave Jensen has the Gould case, and I want to talk a little bit about one of the cases that I have, which is Rogers versus Graywall. Now this is a challenge to New Jersey's highly restrictive carry law. As you may know, there are still a few jurisdictions where carry is very, very highly restricted. New Jersey is one of them, of course, New York, California, Maryland, Hawaii. And so this is a challenge. You may remember from years ago the Drake decision from the United States Court of Appeals for the Third Circuit, where Second Amendment Foundation challenged the New Jersey law back then, and unfortunately the result went against us. This time, we decided to bring the case again in light of the very, very positive decision in the United States Court of Appeals for the District of Columbia in the Wren and Grace cases. And so now we have a petition sitting at the Supreme Court again, awaiting the results in the New York City case. And we're all hoping for a very good result. We'll see what happens. We'd like to see not just a positive result, but a result that will guide the lower courts who have really been abusing the decisions in Heller and McDonald. We've been seeing, for 10 years, we've been seeing the courts coming out with all sorts of absurd results based upon a twisting and turning of those decisions. And so hopefully we'll see something in the New York City case that will set the lower courts in the right direction. And hopefully we'll see some guidance and some further proceedings in Gould and Rogers and in Pena and some of the other cases. I know the Second Amendment Foundation also has a case called Mance, which is also sitting at the Supreme Court waiting to see what happens. So that's a case where, I think as folks have mentioned, argument in the New York City case is December 2nd, and presumably we'll see what they do with that. I want to talk about another case. This is, everybody knows how bad New Jersey is. Some people know a little bit better how bad New Jersey is, but everybody understands that it's a terrible place when it comes to gun rights. Well, what not a lot of people know is that we now have a very, very anti-gun attorney general. And what he's trying to do is he's trying to export his very, very anti-Second Amendment views and exert power outside of New Jersey. And what they've done is they've developed a new legal theory under New Jersey's consumer fraud law. New Jersey's consumer fraud law is a statute that is very widely and very broadly construed by the courts. It gives the Attorney General very substantial power to proceed against sellers of goods on the basis of on the theory of fraud. And so what the Attorney General now contends is that it is a violation of the consumer fraud statute, that it is a commission of consumer fraud to sell a product to New Jersey buyers without disclosing the law that governs the product's use. Now think about that. It is fraud, according to the Attorney General, to sell a product unless you give legal advice as to how you could violate New Jersey law with that product. Now that's an enormous power grab, and it really represents a massive expansion of executive authority in New Jersey. Now, the case that I'm handling involving this new theory of law, and we're concerned about it because we think that if the Attorney General in this sort of test run is successful, he'll continue to export this theory as to other companies trying to sell goods to New Jersey buyers. So in this case is called Graywall versus James Trombley and U.S. Patriot Army. So the Attorney General has sued a website operator named James Trombley, and he operates a website called U.S. Patriot Armory, and they sell lots of things, but one of the things they sell are 80% receivers. And the allegation is that 80% receivers are not per se illegal in New Jersey. They passed a law last year which said it's illegal to buy them with the intent to finish them into an unserialized firearm without a manufacturer's license. What the Attorney General is saying is that it's fraud to sell those to New Jersey without telling people that it's illegal to finish them, to have the intent to finish them into an unserialized firearm without a manufacturer's license. Now, if you can sue someone for fraud because they didn't advise you on the law as to how you can misuse the product and get into trouble, you can really sue anybody. You can sue Macy's for selling kitchen knives without telling them that it's illegal to carry a kitchen knife in your pocket as a weapon, which it is in New Jersey, by the way. You can sell, you can sue a car dealer for selling a car and not informing them that it's illegal to exceed the speed limit. So we're pushing back on this lawsuit. We're hoping to defeat this new legal theory in its infancy to prevent it from spreading around the country. Thank you.